This video focuses a little bit on the second of the two gerrymandering cases that you have to know in the Congress unit. And this is the more recent of the two cases. This case is Shaw v. Reno from 1993. And Shaw is a white North Carolina resident, and Reno is Janet Reno, who is the Attorney General of the United States for Bill Clinton at the time. She basically was the person running the Department of Justice, which is a cabinet position. And this case is going to be involved over a dispute regarding that district you see in the upper right hand corner, which is North Carolina's 12th district. All right, here's the background. North Carolina, unfortunately, had a history of not really electing many minority representatives to the House of Reps. In fact, in 1990, they had zero minority reps elected from North Carolina, despite the fact that African Americans made up 20% of the state's total population. So, again, in the background, you have to take note that North Carolina has a history of, unfortunately, not having diverse representation. Also, 1990 is a census year. So we go through the process of reapportionment, and as a result of that process, it was determined that North Carolina was going to get an extra representative in the upcoming redrawing and reapportionment system. So basically, they're getting a 12th congressional district. So they have to go back and they have to redraw their district maps as a result of this. Okay, here's some historical background information. In 1965, the Voting Rights Act was passed by Congress. In the upper right hand corner, that's President Lyndon Johnson, basically under the guidance of Dr. Martin Luther King, basically signing this into being. Among other things, this law is really significant because it tried to eliminate a lot of the obstacles that southern states had put into place to prevent African Americans from voting after the 15th Amendment was ratified about 100 years before this law was passed, right? So, one of the things that it does is establishes a pre-clearance system. So what does this mean? All the states in the green, right, on the map in the bottom, basically were put on a list. The list basically indicated that within those states, there was a history of discrimination against minority voters. They basically did like a formula system, and if a really low number of minorities was voting within that state, you're basically put on the list. You'll notice that North Carolina is on the list. If you're on this list, what that basically means is that you have to basically get pre-clearance. That means that before you make any changes to your voting process, you have to get permission from the Department of Justice first, because they have to determine whether or not you are going to be attempting to make legitimate voting changes in your state, or if you're back to your old ways of discriminating against minority voters. So you'll notice Pennsylvania is not in the green color. That means we didn't have to make changes, right? Or we didn't have to get permission when we made changes from the Department of Justice, but North Carolina does. So when North Carolina draws its districts because of the new census data in 1990, and because they're on this list, they have to basically submit the new list because it's a change to the voting process within the state to the Department of Justice. So North Carolina submits the changes, and the Department of Justice rejects this, the new drawing of the districts. And what they basically tell North Carolina with very specific instructions is that they want this 12th district to be what we call a majority minority district, meaning they want the district to be drawn intentionally to capture as many African Americans as possible so that the African American demographic, which is the minority in the state, will become the majority within that district. So that's essentially the Department of Justice's role in this, is when they're reviewing North Carolina's new district plan, they reject it and tell them that they want a majority minority district to be drawn. And because the hope of the Department of Justice is that with African Americans in the majority within a singular district, it will at least hopefully lead to the election of an African American representative. Okay. So several white voters, including Shaw from this district, basically sue, saying that these districts were racially discriminatory. You can see that the district in the purple that kind of stretches for hundreds of plus miles across the entire almost width of the state. That's the 12th district. That's the majority minority district. And white voters basically object that the focus on race in the drawing of districts is discriminatory. Because we're talking about discrimination again, it's 14th Amendment Equal Protection Clause, just like it was for Baker v. Carr. So again, it's white voters alleging that the focusing of race in the drawing of districts is discriminatory, and they're challenging the legality of this. The decision that the Supreme Court has to make is whether or not these majority minority districts are discriminatory against white voters within these districts, right? So it's an interesting question because the Supreme Court had previously decided in the 1960s that the districts couldn't be drawn to intentionally hurt minority groups. Like some southern states were doing that, and that was discriminatory. But they had never decided the question or answered the question whether or not the districts could be drawn to intentionally benefit minority groups. However, the decision is 5-4 that yes, these districts are indeed discriminatory, even if they're drawn in a way to try and benefit and help the voting power of minority groups like African Americans in this case. The importance and long term significance is that race cannot be used as the sole factor of the drawing of these districts, whether it's hurting minority groups, which have been previously decided, or like in this case, intentionally trying to help minority groups. The Supreme Court said it was uncomfortable with the presumption that just because African Americans were made to be the majority in a district, that they would automatically be determined to vote for African American candidates. They were also concerned that the people living within this district didn't really have much in common with each other because they were so spread out, except for the color of their skin, and that was uneasy to them as well. So the outcome of Shaw v. Reno is that race cannot be used as the sole factor in the drawing of representative districts.